In the early morning hours of March 13th, officers from LMPD executed a search warrant at 3 Springfield Apartment 4. This was Miss Breonna Taylor's residence. The officers were advised by superiors to knock and announce their presence in serving this specific search warrant. The scope of our investigation did not include the obtainment of that warrant by LMPD's Criminal Interdiction Division. Federal law enforcement partners are conducting that investigation. Sergeant Mattingly and Detectives Cosgrove and Hankison had no known involvement in the called into duty as extra personnel to effectuate the service of the search warrant. They only had information conveyed to them during their prior briefing. Evidence shows that officers both knocked and announced their presence at the apartment. The officers' statements about their announcement are corroborated by an independent witness who was near in a proximity to apartment 4. In other words, the warrant was not served as a no-knock warrant. When officers were unable to get anyone to answer or open the door to apartment 4, the decision was made to breach the door. After breaching the door, Sergeant Mattingly was the first and only officer to enter the residence. Sergeant Mattingly identified 2 individuals standing beside one another at the end of the hall, a male and a female. In his statement, he says that the male was holding a gun, arms extended, in a shooting stance. Sergeant Mattingly saw the man's gun fire, heard a boom, and immediately knew he was shot as a result of feeling heat in his upper thigh. Kenneth Walker fired the shot that hit Sergeant Mattingly, and there is no evidence to support that Sergeant Mattingly was hit by friendly fire from other officers. Mr. Walker admitted that he fired 1 shot and was the first to shoot. In addition to all the testimony, the ballistics report shows that the round that struck Sergeant Mattingly was fired from a 9mm handgun. The LMPD officers fired 40 caliber handguns. Sergeant Mattingly returned fire down the hallway. Mattingly fired 6 shots. Almost simultaneously, Detective Cosgrove, also in the doorway, a matter of seconds. In total, 6 bullets struck Ms. Taylor. Medical evidence obtained by our team indicates that only 1 shot was fatal. Further medical evidence shows that Ms. Taylor would have died from the fatal shot within a few seconds to 2 minutes after being struck. Detective Hankison fired his weapon 10 times, including from an outside sliding glass door and through a bedroom window. Some bullets traveled through apartment 4 and into apartment 3 before some exited that apartment. At the time, 3 residents of apartment 3 were at home, including a male, which of the 3 officers fired the fatal shot. Analysis to see if they reach the same results. The FBI ballistics analysis concluded the fatal shot was fired by Cosgrove. The office looked at both reports to determine if there were major differences in the procedures used by each lab that would have led the FBI to identify who fired the fatal shot. Both lab is highly respected for their work. There was nothing our investigators could point to, nor anything provided by the respective agencies that directly explains why one lab made the call while another did not. I think it is worth repeating again that our investigation found that Mattingly and Cosgrove were justified in their use of force after having been fired upon by Kenneth Walker. Secondary to this justification, the KSP and FBI ballistics analysis reached different conclusions, creating a reasonable doubt in the evidence about who fired the fatal shot. I certainly understand the public's desire for answers, and many have questioned the length of the investigation. Simply put, we had to try every means necessary to determine who fired the fatal shot before the investigation could be. With a thorough all evidence collected in this case, lawyers with our Office of Special Prosecutions presented the findings of our independent investigation before a grand jury comprised of Jefferson County residents beginning on Monday and concluding today. In Fletcher v. Graham, the Kentucky Supreme Court said that the grand jury has competing but balanced functions. On the one hand, its purpose is to investigate allegations of criminal conduct and determine if there is probable cause to believe that a crime. The grand jury serves to protect the public against unfounded criminal prosecutions where probable cause is lacking. The grand jury is unique in our criminal justice system because it operates independent of the court and the prosecutor. The hallmark of the grand jury is its independence from outside influence. This independence is necessary to ensure that justice is done both for the victims and for the accused. The evidence from our team of prosecutors, the grand jury the three individuals in apartment 3 in danger of serious physical injury or death. The charge of wanton endangerment in the first degree is a Class D felony, and if found guilty, Kentucky law states that a person is guilty of wanton endangerment in the first degree when under circumstances manifesting extreme indifference to the value of human life, he wantonly engages in conduct which creates a substantial danger of death or serious physical injury to another person. My office is prepared to prove these charges at trial. However, it's important to note that he is presumed innocent until proven guilty.